In this lesson, we're going to go over the most frequently tested and highest yielding areas of wills on the bar exam in 60 minutes or less. Or in other words, we're going to go over the absolute must-know stuff in wills for the bar exam, which historically, if we look at the data, is going to be the will execution requirements, integration of documents into the will, including the incorporation by reference doctrine, Codicils. Of course, after we talk about will execution and integration, we're going to have to think about how a will can actually be revoked and how prior wills that have been revoked could potentially be revived. With this, we'll also talk about the dependent relative revocation doctrine. Finally, after we get past revocation and revival of the will, we can talk about some of the commonly tested construction problems, which are going to be anti-lapse statutes, ademption, slayer statutes, disclaimers, and devises to classes or class gifts. Finally, we'll wrap the lesson up with some will contests, basically when someone wants to challenge the validity of a will. And the main two challenges we'll focus on, which are most commonly tested, are going to be capacity and undue influence. But with that, guys, we have a lot to cover here, so I'm just going to jump into it. I'm going to try to do the best I can to get through all of this in 60 minutes. But with that, we can just set our timer to 1 hour. Ready, set, go. So the clock has officially started. Probably the best place to start here is, well, what is a will, right? Most of us probably have a good idea, right? From experience, we probably understand what the will is used for. But big picture, right? If you remember back from our last lesson, we said kind of if a person does not have a will or some other document that describes where their property should be disposed of at death, the intestacy laws of the applicable jurisdiction direct where property is distributed at death. So if a person dies without a will, they don't have any other type of document that directs where the property is distributed, we know that the intestacy laws of the applicable jurisdiction will direct where that property goes. But if a person doesn't want the law of the applicable jurisdiction to decide where their property goes, basically they don't want the state to decide for them where their property is distributed, one way they can modify this is by executing a proper will, right? In a will, a person can direct where their property should be directed or where their property should be disposed of at death, right? Maybe you want to leave property to some sort of charity you like. Maybe you want to disinherit somebody, right? Maybe you have a son or something who's entitled to a share under intestacy law, but you want to disinherit that person, right? The will is a way that you could disinherit somebody. So there's a lot of reasons somebody might want to execute a will to direct where their property should be distributed at death. So what are the requirements? How do you validly execute a will? Well, generally we have 5 elements, right? And of course this is going to vary from jurisdiction to jurisdiction, but traditionally we have 5 major elements, right? To be valid, a will must be in writing. It must be signed by the testator or another. It must be attested in the testator's presence by competent witnesses. And these are kind of our 5 elements. Number 1, it has to be in writing. This is pretty straightforward. Of course, nowadays in modern times, you're going to have some jurisdictions that allow for basically video wills where a person could be recorded, right? And you could have kind of a video version of a will. But for our purposes on the bar exam, right, the traditional rule is that a will has to be in writing. It's going to have to be signed, right? Typically, this requires some mark on the will and intent for the signature to be a validating act, right? So you don't actually need somebody to sign their full name, right? Any mark will suffice. They could put their initials, they could put, an X, whatever, right? A mark will work as a signature so long as that mark was intended to be a validating act, right? So one thing you might see tested is a person kind of writing their will, and they say, I, Michael, leave blah, blah, blah to this person. And, that is not necessarily just writing your name on the paper is not necessarily meant to be intent to validate the will. You were just writing your name on the paper, right? So we want to see that mark being used to actually have the intent, right? When that mark is made, the intent for that signature or that mark to be a validating act of the will. The signature at the end usually that says, okay, now I'm validating this will. Right, of course, we say also that the signature has to be made by the testator or another person. So obviously, if a person has a physical disability or something, there could be a lot of reasons somebody might not be able to sign their own will. Of course, in most jurisdictions, right, you're going to be able to use a proxy. Another person may sign the will for the testator if it is done at the testator's direction and in the testator's presence. Right? The testator, by the way, I'm going to use this word a lot, is just the person who is executing the will. This is the person who's got property that he wants to distribute by will. That's who we refer to as the testator. Right? And a way you can think about this, remember in our last lesson, we said if a person dies without a will, we say they die intestate. If they have a will, they're a testator, right? They've died testate, making them the testator, right? So anyway, so going back into this element, so it can be signed by the testator or another, right? And another person may sign as a proxy on behalf of the testator if it's done at the testator's direction and in the testator's presence. So sometimes you could see this tested as like a lawyer, right? This would be a classic kind of fact pattern. A testator hires a lawyer to draft a will for him on his behalf, and then he asks the lawyer to sign the will for him. Right, well, it depends on where the lawyer is when that happens, right? Because that would meet the first part of this, right? That is at the testator's direction, but is it in the testator's presence, right? Typically, we'd want to see the lawyer nearby, right? It couldn't be over the phone or something like that, right? The lawyer's in a different state over the phone being directed to sign on his behalf. That's usually not going to work, right? It has to be in the testator's presence. And we're going to define what presence is in a second, right? We have two different rules. We kind of have a traditional approach and a modern approach. We have the traditional line of sight test and the conscious presence test, which we're going to talk about in a second. But for now, just accept, right, that we do need, if a proxy is going to sign on the testator's behalf, they have to be nearby, usually either in the line of sight of the testator or within the range of senses of the testator, within earshot, within vision, within arm's length. You couldn't have somebody over the phone or something like that signing on behalf of the testator. Right. Of course, next we have to have witnesses. Typically, in most jurisdictions, we have to have the will has to be attested in the testator's presence, right? So we're going to need some witnesses to attest to the will. This is usually done by 2 or more competent witnesses signing off on the will. Right, but what does it mean to be attested in the testator's presence? This is what we were getting into with the line of sight test and the conscious presence test. So the traditional view is that to attest a will, for a witness to attest a will in the testator's presence, that witness has to be within the line of sight of the testator, right? So if I am having somebody sign, or if I'm having a witness attest to my will, right? I'm the testator. That witness, whoever those 2 witnesses are who are attesting to my will, have to be within my vision at the time of execution of that instrument, right? If those witnesses are in a different room right outside the hall and I can't physically see them with my 2 eyes, that fails the line of sight test, right? If there's a pillar in the room and just the way we happen to be standing, I can't see one of the witnesses, right? He needs to take a step to the left or a step to the right to become in my line of sight, then he's not within my line of sight, right? That fails the line of sight test, right? So you can see that's a really narrow, strict test, and it doesn't make a whole lot of sense in certain situations. So the more modern approach is going to be a conscious presence test, where we say, look, you don't have to actually be in the testator's line of sight any range of senses. So if you're within earshot, if the testator could reach out and touch you and feel you, if they can see you, as long as you're within any of the range of senses, that's going to satisfy the test. So the classic kind of way you can distinguish between the 2 in your head is think about the guy in the hallway, right? Who's out of the line of sight but can clearly hear the testator, right? Under the line of sight test, right, if a guy's out in the hallway outside the room, right, well, that fails the line of sight test. That witness is not within the testator's line of sight, but it is within earshot, right? That witness is within earshot of the testator. So that would fail the line of sight test, but pass the conscious presence test, right? Finally, the witnesses, right? And remember, we usually need 2 witnesses. We say the witnesses have to be competent, right? So you couldn't have a witness who's like legally insane or something like that. But another thing that's interesting is that in some jurisdictions, right, to be competent, we say that the witnesses have to actually be disinterested, right? This is an old common law rule, but it's still followed in some jurisdictions, right? To be competent, the witnesses have to actually be disinterested, which means the witness is not receiving any benefit under the will, right? To be disinterested, the witness has to not be receiving any benefits under the will, right? So in those jurisdictions that are following that approach, if you have an interested witness who's attesting to the will, right, it's not going to in of itself invalidate the will as a whole. What's going to happen is you generally have what are called purging statutes that are going to reduce the share of that witness, right? So if that witness is receiving some benefit under the will, right, that purging statute in these jurisdictions that follow this approach is going to reduce their share, typically to whatever they'd be entitled to under the applicable jurisdiction's intestacy law. Right, so if you have an interested witness and you're in a jurisdiction that requires the witnesses to be disinterested, right, that doesn't necessarily invalidate the will as a whole. What that's typically going to do is just reduce that interested witness's share of the benefit of the will to basically whatever they'd be entitled to under intestacy law. Right, also important to recognize that under the Uniform Probate Code, or the UPC, a signature from a notary can validate a will. So basically this is a substitute for having 2 competent witnesses. You can go to a notary. A valid signature from a notary would satisfy this element, and any jurisdiction that's following this section of the Uniform Probate Code. But those are your 5 requirements to validly execute a will, right? It's got to be in writing and signed. It's got to be signed by the testator or another, right? Another person may sign if it's done at the testator's direction and in the testator's presence, right? It's got to be attested basically by 2 or more competent witnesses in the testator's presence. That's usually going to require that the witnesses sign off on the will. So those are our 5 requirements to execute a valid will. Next, we can move into integration of documents into the will. Right, so let's just talk about incorporation by reference. So in most states, extrinsic documents may be incorporated into a will by reference if 3 elements are met, right? The testator intended to incorporate the document into the will, the document was in existence at the time the will was executed, and the document is sufficiently described in the will. So something that you can have classically tested as a fact pattern, right? Imagine that you have a testator who executes 2 different wills, right? And let's just call it will number 1 is executed first, will number 2 is executed second, right? Well, let's say that will number 1 is not executed properly. It fails to satisfy one of these elements, right? Maybe the testator forgets to sign it, it's not signed properly, it's not witnessed properly, right? There's something wrong with the execution of the first will, right? And then later on, we have execution of a second will. Right, so we have an attempted execution basically of will number 1, but it's invalid, and then we have an proper execution of a second will. Right? Very important to recognize that whatever that piece of paper is, right, we have this writing that looks like a will, but it wasn't properly executed. That writing essentially has no legal effect by itself. You should just think of it as just some piece of paper floating around, right? It has no legal effect for our purposes, right? In the distribution of property, it's a worthless piece of paper, right? But it can become meaningful basically for our purposes on the bar exam in only one way, right? Where a will was failed to be executed properly. That piece of paper can become important if it's incorporated by reference into a subsequent will. Right? In most states, extrinsic documents may be incorporated into a will by reference if these 3 elements are met. So in that example, what could happen, that floating piece of paper that had no legal significance for us can become legally significant legally significant if it's incorporated by reference into a validly executed will. Right? So if the testator intended to incorporate the document into the will, the document was in existence at the time the will was executed, which it would be there because that failed attempt happened first. So it did exist, right? Our extrinsic document exists. That floating piece of paper existed. So it's going to come down to whether the testator intended to incorporate it and whether the document is sufficiently described in the properly executed will. If those two elements are met, because element number 2 we know is met, it was in existence at the time, right, the will was executed. So it's going to come down to element 1 and element 3. And that would just be looking at the fact pattern. Did the testator intend to incorporate that floating piece of paper, right, into the will? And was that document sufficiently described in the will? If both of those are satisfied, then that piece of paper that had no legal significance, right, that failed attempt to execute a will now becomes part of the will, right, if all 3 of those are met. Now let's compare that to what happens with codicils, right? So a codicil is a supplement or addition to a will made after a will is executed. Right, so a codicil has to meet the same formality requirements that a will has to meet. It has to meet these 5 elements. To validly execute a codicil, right, you have to satisfy these 5 elements. It's the exact same as executing a will. Same formality requirements. Right, so if a codicil is validly executed, right, meets those 5 elements, the effect is going to be that the original will is treated as republished. Right? So it's like the will got republished on the day that the codicil was executed. Now it's extremely important to recognize that the original will is only treated as republished if the original will was properly executed. Right, so in our fact pattern, remember, same hypothetical, will number 1 is not properly executed. Let's say later down the line, a codicil is properly executed. Right, does that codicil republish the original will that was improperly executed? The answer is no. Right, and this is sometimes tested on the bar exam. Right, a codicil cannot revive an improperly executed will. In no situation, if the original will was improperly executed, one of these elements didn't happen, even if a codicil is later executed validly, right, it does meet all these requirements, it's not going to revive a prior will that was not validly executed. Remember, the only way that that legally insignificant piece of paper becomes part of the will if it's incorporated by reference, right? A codicil cannot save that floating piece of paper, that insignificant failed executed will, right? Now, having said that, there are some situations where a codicil could defect specific problems, could cure specific defects, right, in the original will. So long as the original will was properly executed, right, it does meet these 5 requirements, right? But say there's some defect in that will, right? And we're going to talk about a lot of construction problems that'll come up. So just bear with me. If there's some defect that's in the will, but the will was validly executed, right? It was in writing, it was signed by the testator or another, it was attested by competent witnesses. We have all the requirements are met. So we have a valid will. And then a codicil is executed that could cure specific defects in the prior properly executed will. Right? So hopefully that makes sense. Right, to give an example, let's say that we're in a jurisdiction that requires the witnesses to be disinterested, right? We're in a jurisdiction that requires the witnesses to be disinterested. Well, let's say that in the first execution of the first will, we had an interested witness. Right? We had an interested witness who was getting a benefit that was larger than their intestate share. Well, we know that that does not invalidate the original will. That's just a defect in the will that's going to reduce their share. Remember, that just reduces their share to whatever their intestate share would be in those jurisdictions. It does not invalidate the will. So in that case, we would have a validly executed will, but we have this defect, right? We have an interested witness where we're supposed to have disinterested witnesses. So if the codicil is now executed with 2 disinterested witnesses, it republishes the original will because the original will was properly executed. So now that defect, that specific defect, is fixed, right? So that disinterested witness or that interested witness can get whatever their gift was going to be that's in excess of their intestate share, right? Because the codicil now republishes, and because the codicil was executed with 2 disinterested witnesses, it cures the defect of the interested witness. Now that interested witness can get whatever their gift was in excess of their intestate share. Okay, so that's incorporation by reference and the codicil. Thank you so much for watching this video preview of our Bar Blitz video series. If you would like to see the conclusion of this video and gain full access to our entire Bar Blitz video library, which includes coverage of the most frequently tested and highest yielding areas of law in each bar exam subject, we invite you to head over to our website and join the thousands of law students who have already enrolled in Studicata Bar Review. To get started with your no-risk free trial today, simply click the link in the description box below or visit www.studicata.com.